Supreme Court Justice Clarence Thomas, who was recently found in a ProPublica report to have been the recipient of undisclosed gifts for decades from billionaire Harlan Crow. So he defended himself by saying, well, I didn't think I had to disclose these gifts. What's wrong? It's just, he's my friend. And, he was just being very, very friendly and lavishing me with amazing, and me and my wife with amazing trips and all this wonderful stuff. The report from ProPublica detailed trips Thomas took on Crow's private plane, luxury yacht, as well as vacations to Crow's private resort in New York and a ranch in Texas. One trip in Indonesia in 2019 would have cost the Thomases about $500,000 if they had paid for it themselves. But here comes Daddy Billionaire coming in and saying, don't worry about it. Thomas, we got this. I got this. Daddy Crow got you taken care of. That's right. Now, in his statement last Friday, after this report came out, Thomas said that the Crows are, quote, among our dearest friends. Gee, I wonder why. You think that way. And we've been friends for over 25 years, and that he and his wife had just joined them on a number of family trips, again, that were all expense paid. He wrote that he had consulted with colleagues and others in the judiciary, I'd love to know who they are, earlier in his career, who advised him that this sort of personal hospitality from close personal friends who did not personally have business before the court didn't have to be reported. Oh, see, they never had business in front of the court themselves. They never filed an amicus. Okay, but I think that Crow was smart enough not to file an amicus himself, because that would, of course, lead to calls for Thomas to recuse himself, especially since this would get out. And by the way, stuff like this has been reported on before anyway. But so they got around it by not having Crow bring things in front of the Supreme Court, but Crow's friends. Crow has links to groups that file amicus briefs lobbying the Supreme Court. A lot of different cases. Pro-corporate cases, mainly. Since Crow was a real estate guy. And his trips also brought Thomas into contact with very wealthy donors and the heads of conservative groups like the Federalist Society. Now, when you look at all that, yeah, that looks like something that you should report because that's definitely the appearance of corruption. As a result, there are Democrats that have pushed for more transparency, and a few have called for Thomas's impeachment. But let's be clear, the lack of transparency is not a new thing for Thomas. He's been corrupt for a very, 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 very long time, and has argued against transparency to hide that corruption. Let me give you some examples here from the lever. Justice Thomas, according to a deep dive into his record, had pushed to invalidate all political spending disclosure laws in America, insisting that donors have a constitutional right to anonymously influence politics with money. Influence, or basically bribe. That's what this is. It's bribes. Okay? Legal bribes. Justice Thomas says, legal bribe, good. I like legal bribes. So here's some examples of some court cases that he had filed some dissents on. In 2010, the Supreme Court issued its Citizens United ruling, which declared that independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption, and therefore could be made limitlessly. But Thomas said, no. I like that, but I don't think it went far enough. In fact, he had previously insisted that there is an established right to anonymous speech, which we know that's a code word for dark money. He had issued a concurring opinion insisting that judges should overturn all rules that require transparency in political spending. Quote, this court should invalidate mandatory disclosure and reporting requirements. He also argued that donors could face retaliation and ruined careers when they disclose their political spending, and cited an example from California in which supporters of a ballot measure ending same-sex marriage were allegedly harassed for donating to the ballot measure campaign. again, you are literally trying to strip people of their civil rights. I would expect a little bit of, hey, why don't y'all stop being, supporting bigots with your money? Just saying. I mean, come on. Thomas decried the prospect of transparency, empowering members of the public to come up with ways to try to shame donors and the public officials that they bankrolled. So, essentially, he has been fighting to protect the donors from the people. Donors who actively donate to causes that are against the wishes of the vast majority of the American people. He is protecting the donors over human beings. Let's make that very, very clear. And as the lever points out, that even in cases where Thomas was on the majority and was in the majority opinion, he also issued concurring opinions arguing that, again, the court didn't go far enough in discarding political spending limits or disclosure laws, asserting that the court had erred in its 1976 decision in Buckley-Vallejo, which had upheld the constitutionality of contribution limits to federal candidates. Quote, by depriving donors of their right to speak through the candidate, this is sick. The whole thing is just sick. Contribution limits relegate donors' point of view to less effective modes of communication. These people have, gigantic dump trucks full of money and all the power to influence politicians. And yet, even with the flimsy campaign contribution limits that we have, this is not enough. We must have more money. We must have more dump trucks full of money. Disgusting. In 2000, this was a 2000 dissent from the court's majority in Nixon v. Shrink, Missouri government PAC, which upheld contribution limits to candidates and committees in Missouri. 2004, Thomas broke with the majority in McConnell versus FEC, which upheld key features of the Bipartisan Campaign Reform Act of 2002, including a ban on limitless contributions to political parties. In that dissent, he argued the majority was allowing the established right to anonymous speech to be stripped away based on the flimsiest of justifications. Thomas similarly defended that right to anonymous speech by campaign donors in Citizens United in 2010, a case where it's been pointed out that watchdog groups like Protect Our Elections, for example, had argued that Thomas should not have been a part of in any way, should have recused himself. Why would that be? Why would a Supreme Court justice have to recuse himself from this very important case? Well, it turns out his own nomination to the court in 1991 had been boosted by six-figure ad spending from the Citizens United Foundation, the very group that brought the case. But again, conflict of interest, don't care. It was later also revealed that Thomas and the late Justice Antonin Scalia had attended conferences hosted by Koch Industries, which uses its massive coffers to pour money into our elections and buy off our politicians, to buy off our government. An additional complaint from the group alleged that Thomas had claimed for over 20 years in federal ethics disclosure forms that his wife, Ginny Thomas, had no non-investment income, even though she had earned a salary for each of those years. Those disclosure forms required Thomas to swear to the accuracy of the information, which he did not. From 2003 to 2009, Ginny Thomas's annual salary of at least $120,000 came from the Koch-backed group Heritage Foundation. Thomas told the Los Angeles Times in the wake of the Citizens United decision that a new conservative lobbying group, Liberty Central, would be accepting donations made legal by the recent ruling. And of course, who were one of the biggest donors? Harlan Crow. He donated the initial $500,000 raised by Liberty Central, according to a report in Politico. Now she runs a consultancy group that takes as clients conservative groups attempting to, get this, influence the outcomes of Supreme Court cases. Well, weird. It's almost as if there's a gigantic, conflict of interest going on here. Weird. Finally, in 2014, after the majority struck down spending limits through, and this is aggregate spending limits from individuals in McCutcheon v. FEC, Thomas still was not impressed. He said, no, we need more dark money, even more dark money. We need the darkest kind of money. Yes, that's right. He said, this case represents yet another missed opportunity to right the course of our campaign finance jurisprudence by restoring a standard that is faithful to the First Amendment. So, but hold on, he's not arguing for the First Amendment. No, he's arguing for legalized corruption. Again, the darkest of the dark money. Anonymous corruption. So, look, the reason that transparency to me is so important and should be important to everyone, even conservatives, is because it's part of the free marketplace of ideas. You see, we should at least have the right to know who the hell is buying our politicians. I mean, it would be nice to know so that we can make a decision in the free marketplace of ideas who to support, and also to look at why these politicians support certain policies, because they don't necessarily do it based on the kindness of their heart. They don't cut taxes for rich people because they think, oh no, you see, I'm just making sure that our poor rich people get a fair shake, because they're just not getting a fair shake right now. No, it's because these politicians get money from those corporations who want to lower their taxes. It is simple as that. It comes down to greed. It comes down to corruption. And it comes down to legalized bribery, which all of these different decisions that Thomas argues did not go far enough were actually way too far, because they had opened up this country and their government, our government, for sale. Look, I know they love to argue that there is no appearance of corruption from lobbying, and we get that argument, by the way, from some Democrats as well. But if that's the case, why are people like Thomas and these conservative groups going to such lengths to hide where the money is coming from? They know. Look, they're more interested in gaslighting us into believing that there is no corruption. They're just talking to each other. The money has nothing to do with any of the decisions of these politicians at all whatsoever. No, it's gaslighting as they continue to take us further into this new Gilded Age.